Hello, my name is Dhruv Sanghvi, and today I'm going to be talking about the definition of the term liable to tax as proposed in the Indian Finance Bill of 2021. Those familiar with tax treaties would know that with some exceptions, a person ought to qualify as a resident of a contracting state to gain access to treaty benefits. This term, resident of a contracting state, is usually defined as a person who under the laws of that state is liable to tax therein by reason of his domicile, residence, place of management, or any other criterion of a similar nature. The international consensus around the interpretation of the term liable to tax is that it implies a comprehensive liability to tax. However, as is the case with most terms of art, this one too is the subject of many a controversy. How comprehensive is comprehensive enough? Must a person actually pay tax to be considered to be liable to tax? And what about exempt entities like charities and pension funds? And what is the significance of all the criteria listed in this definition? There are more aspects to this definition, but that is for another time. A most interesting aspect of tax treaty interpretation is that undefined terms contained therein adopt the meaning that they have under domestic law of the state applying the tax treaty. So, the obvious question arises, whilst the term liable to tax is undefined, why not just define the term under domestic law? Well, this is exactly what the Finance Minister has done in her budget this year. However, this rule of interpretation is subject to a major caveat, and that is that the domestic law meaning of the term should not exceed what is considered to be the context of the tax treaty. Does the proposed definition of the term liable to tax in the Indian Finance Bill of 2021 exceed these contours? That is what we're discussing in this video. Let us refer to the actual definition proposed in the Finance Bill. Liable to tax in relation to a person means that there is a liability of tax on such a person under any law for the time being in force in any country and shall include a case where subsequent to the imposition of a tax liability, an exemption is provided. The reference to any tax in this definition seems to follow the line of a rather questionable decision of the Bombay High Court in the case of Chiron Bearing. In this case, the Bombay High Court had held that because a fiscal transparency established in Germany had to pay a trade tax in Germany, which was listed as a covered tax in Article 2, that it was liable to tax and therefore a resident of Germany. However, a trade tax is not a personal tax in that it is not attached to a person based on that person's personal characteristics or that person's nexus with that state. A trade tax, on the other hand, is an impersonal tax and applies to any person, whether a resident or not. Therefore, the trade tax is unlikely to qualify as a comprehensive tax liability. However, that ratio seems to have been adopted in this definition, and it would remain to be seen whether any tax under any law could also imply that a person who is liable to paying, let's say, a value-added tax or a goods or services tax in a country would now be considered to be a resident of that country. If that is really the case, then I suppose most taxpayers would qualify as residents of almost every country with which India may have concluded a tax treaty. This seems to be surely an unintended consequence of the definition. Perhaps it is intended by the Finance Ministry to grant treaty access to fiscally transparent entities, and that would indeed usher a great deal of certainty, but it must be clarified what one means by any tax under any law of a contracting state, lest it should only lead to more litigation. Not all thresholds, however, seem to have been reduced or lowered in the case of this definition. The term liable to tax is generally accepted to not require a person to actually pay tax. However, the reference to a liability of tax as opposed to a person being liable to tax might make a difference. A liability of tax may imply that there ought to be a payment of tax, as opposed to the term liable to tax, which it is generally accepted means a liability to a liability of tax. This argument might be buttressed by highlighting the use of the terms imposition of tax and subsequent exemption. Now, this interpretation is surely not intended, as I was told by the draftsman of the Finance Bill on another forum. However, if that is really the case, we would propose a different formulation of the concept of liable to tax, not as a definition, but rather as a clarification. We propose the following clarification. A person who is generally liable to tax, but is specifically exempt from paying tax under the laws of a country, is nonetheless considered to be liable to tax in that country.